clock shows 7 a.m. Your trip has taken 14 hours. You are very tired. Your luggage is weighty and you only wish to clear the airport and go home. You step to the CBP officer's booth. You pass your passport under the window and all seems fine. Then the officer checks his monitor. He does not give your passport back. He types. He lifts a telephone. Then he speaks 4 words that cause concern. Please come with me. You are led to a rear area. The door shuts. A different officer faces you and opens your record on his screen. He looks at you and states, I need 5 years of bank records. In that second, you see you have nothing. You lack documents. You have no printed proof. You do not know why he asks. While you sit there deciding what to answer, a timer has started on a procedure that could finish with you on a plane to your home nation by evening with a 5-year restriction noted in your file without a hearing, without a judge, and without another opportunity. This is not a story. This occurs to actual visa and green card holders now at airports and land borders across the United States. If you do not know precisely why this occurs and precisely how to act, you are in serious danger. Let me describe what most people incorrectly do here. This is where the difficulty lies. It is a situation that has already impacted thousands regarding their immigration standing, their jobs, and their lives in America. When a border officer requests financial papers, most individuals react in one of 3 ways. They feel alarmed and speak excessively, offering details they should not share. They act guarded, which the officer may view as unusual conduct. Or they give no helpful response because they did not prepare, never expected this, and thought a valid visa meant the difficulty was finished. All 3 reactions can speed the route to what is named an expedited removal order. If you get one, your circumstances change immediately and greatly. Under an expedited removal order, you are refused entry to the United States immediately. Your visa is voided at once. You are booked on a direct flight from the nation, often within 1 to 2 days, and you are prevented from re-entering the United States for 5 years. There is no immigration judge, there is no court session, there is no standard appeal method. The officer who interviews you also gives the order. Based on legal analysis from the Murthy Law Firm and CBP's operational guidelines, this process is lawful, active currently, and applies to H-1B workers, F-1 students, B-1 and B-2 visitors, green card holders coming from abroad, and nearly every other immigration class you can name. The result depends on the CBP officer's judgment in that moment in that room that you are ineligible. So the issue is not whether this might affect you. The issue is whether you are ready. Now let me share the legal context you must understand because information is your defense. Under the Immigration and Nationality Act, specifically Section 212, a person requesting admission must show they are not inadmissible under any listed reasons. One reason in Section 212A4 is the public charge reason. This means if a CBP officer has cause to think you cannot support yourself financially in the United States or that you may become mainly reliant on government support, that officer can find you inadmissible. Financial papers, including bank statements, are a primary tool CBP uses to assess your self-support ability. This is not new law, but what is new is how vigorously and widely it is now used. Since January 20, 2025, executive orders have greatly expanded the enforcement stance of CBP and ICE at ports of entry. Officers now work under clear instructions to perform more complete financial and personal checks during admission interviews, especially in secondary inspection. Due to the biometric entry-exit rule active since December 26, 2025, every non-citizen's face is now compared to government systems when they near a CBP booth. If that match reveals any alert in your history, any inconsistency, any lapse, any past immigration matter, the chance of secondary inspection rises greatly. In secondary inspection, the officer has wider power, more time, and more resources. Under CBP Directive 334049A, they may legally examine every application on your phone, including your banking apps, payment apps, and any financial data visible on the device. This is the setting you enter each time you cross a United States border. Currently, here is where I must pause and discuss something spreading quickly on social media, on TikTok, and in WhatsApp immigration groups because it is unsafe and incorrect. A statement is circulating that CBP has no right to ask about your finances, that only USCIS can assess financial eligibility, and that asking for bank statements at the border is an unlawful overstep. This is untrue. CBP has full legal authority under the INA and under DHS rules to evaluate financial admissibility at the port of entry. Another statement suggests that if you have a valid visa, you cannot be denied entry for financial causes. Also untrue. A visa permits travel to the United States to request admission. It is not an entry guarantee. The CBP officer at the port makes the final admissibility choice, and that officer is not limited by the decision of the consular officer who gave your visa. I have read comments advising people to refuse financial questions by citing the Fifth Amendment right against self-incrimination. As a non-citizen seeking admission at the border, you do not have identical Fifth Amendment protections as a person inside the country facing criminal charges. Declining to cooperate with a CBP admissions interview is practically seen as a failure to prove admissibility, and that failure can and does lead to entry denial. These ideas are not just false, they are hazardous. Following that advice can place you under an expedited removal order quickly. Now let me give the action plan because this part will truly protect you. Later, after viewing this video, here is exactly what you must do. First, collect your bank statements from the past 5 years now. Access your bank's online system. Download your monthly statements for the last 60 months and store them in a well-named folder, both on your device and in cloud storage you can reach from any location. If you use several banks, do this for each account. When a CBP officer asks you to show financial stability, you should display a clear, steady financial history. You should show regular income deposits. You should show that your funds are sufficient for your planned visit, and you should show no unusual large money transfers in the account. If your statement history shows uneven activity, address that by preparing a brief written note for your files. Second, print and carry a paper copy of your latest 3 months of statements each time you travel abroad. Yes, print it on paper. CBP officers have recognized authority to inspect your phone, but they cannot force you to open cloud accounts or distant servers. Having paper documents ready shows you expected the question, that you are transparent, and that you are a ready, orderly traveler. That alone changes the tone of the exchange. Third, know your admissibility history before you travel. Access your I-94 record at the official CBP site i94.cbp.dhs.gov and verify your prior arrivals and departures are correctly noted. If you see any errors, fix them before your next international journey, not during a secondary inspection when it is not timely. If you have ever stayed past a visa date, had a prior removal, or had any problem at a United States border, talk with an immigration lawyer before you travel. These alerts will show in the CBP system when your biometrics are scanned. An unready traveler with an alert in their history is precisely the type directed to the secondary area. Fourth, if you are a lawful permanent resident, meaning you have a green card and you travel internationally, you must carry proof of your connections to the United States in paper form each time you cross the border. This includes your newest tax return or tax transcript, your work records or pay slips from the past year, proof of your United States address, like utility bills or rental contracts, and preferably a note from your employer confirming your current job. Green card holders can be sent to secondary inspection like any traveler. In secondary, the question of whether your residence in the United States is truly ongoing may arise. Bank statements from a United States account showing steady United States activity over many years are among the strongest evidence you can provide. Fifth, if you are ever taken to secondary inspection and a CBP officer starts asking specific financial questions, here is exactly what to say and how. Stay calm, be straightforward. Do not explain too much. If the officer asks where you work, state clearly, "I am employed by." Then give your employer's name and your position. If the officer asks about your finances, say, "I have my bank statements ready if you wish to see them." Then offer the printed copies you prepared. If the officer asks something you truly do not grasp, it is entirely suitable to say, "I want to ensure I understand the question properly. Could you please explain?" You are not avoiding. You are being exact. What you should never do is offer information that was not requested because in a high-pressure secondary inspection, additional information almost always creates more questions, not less. Sixth, this is vital. If you receive any paper during a secondary inspection, whether it is a sworn statement, an interview summary, or any form with your name and case number, keep every copy. These papers are the base for any future legal assessment, any reconsideration request, or any waiver application. According to guidance from immigration law firms, including Murthy Law and Verdun Law, mistakes and misunderstandings by CBP officers can occur, and a written account of what was said is crucial if you need to contest a decision. My name is Junie. I am a senior immigration analyst with 6 years of work. On Immigration Senior US, I do not offer opinions. I provide the practical guidance that helps families stay united. What you just learned is not designed to scare you. It is designed to equip you. Because the border situation in 2026 is the most stringent it has been in decades. The people who pass through without trouble are not those with the costliest lawyers or the strongest visas. They are those who arrive prepared. Immigration policies can change suddenly. Join my WhatsApp community for immediate notices before I post on YouTube. The link is in the description below, and I suggest you join that group before your next trip. As a note, everything discussed in this video represents confirmed information as of March 24, 2026 from official CBP, DHS, and INA sources, plus review from Murthy Law, the American Immigration Council, and the National Immigration Law Center. This material is for educational use only. It is not legal counsel. For your personal case, please see a qualified immigration attorney. Policy changes can and do happen. Always check official sources before you travel. If this video assisted you, like it now and share it with every visa holder and green card holder you know. It might be the most crucial thing they view this year. If you want correct, quick, and dependable immigration news, subscribe to Immigration Senior US now and enable alerts. Staying updated is no longer a choice. It is necessary. I am Junie. Safeguard your status. Safeguard your family.